Hi, I'm Matthew Robinson, Senior Associate of Dundas Lawyers. Dundas Lawyers is an award-winning corporate technology and intellectual property law firm and also passionately litigates in these areas of practice. In this video, we discuss whether a beneficiary of a trust, be it a unit trust or a discretionary trust, has the right to obtain the trust deed by requesting it from the trustee. This can be important as one of the first signs of disputes involving equity holders, i.e. unit holders or beneficiaries of the trust, is usually the restriction of access to information by those who control it. The saying that information is power does have a lot of merit. A trust deed is an essential document because it contains the rights and obligations of the parties in relation to the trust property. This is useful when a beneficiary is seeking to understand their right to distributions and/or the powers of the trustee controlling it. In Queensland, the statutory rights and obligations of trustees are contained in the Trust Act of 1973. The role of the trustee is fiduciary in nature, meaning they must act in accordance with the terms of the trust deed, their duties under the Trust Act, and their duties under common law. However, the Trust Act does not expressly require a trustee to provide a trust deed to the beneficiaries. That said, common law provides beneficiaries with a prima facie right to make such a request to the trustee. This prima facie right is known as the Trust Documents Rule, and the reasons for it are summarised as follows. Trust documents in equity are the property of beneficiaries, and therefore beneficiaries have an absolute right to access trust documents, and beneficiaries also have a right to trust documents because trustees are bound by the fiduciary duty to keep the beneficiaries informed and their liability to account to the beneficiaries. The Trust Document Rule is accompanied by the General Rule, which was established in the New South Wales decision of Hardican Nominees Pty Ltd and Ridge. This was also affirmed in Queensland Supreme Court case of Colston and McMullen. The General Rule can be summarised as: a trustee is obliged to provide information upon request of beneficiaries when the information is in relation to the trust property and provides the accounting in respect of its administration. In general, a trust deed fits this description and therefore a beneficiary has a prima facie right to view it. So what can be done if a trustee won't provide a copy of the trust deed? In Queensland, a beneficiary may apply to the court to review the acts and/or the decisions of the trustee if they refuse to disclose the relevant trust documents pursuant to Section 8 of the Trust Act. An application can also be made by a beneficiary under Section 94 sub 3 of the Trust Act for the court to make orders in relation to a beneficiary's entitlement pursuant to the trust deed when it is difficult or impractical to effect the disposition of transactions without assistance of the court. Knowing your rights as a beneficiary to request trust documents is paramount in circumstances where the trustee is refusing to disclose the trust deed. Any party concerned about their rights and obligations in a trust should seek legal advice so that they are aware of their rights and obligations. If you're looking for a lawyer to advise you on matters involving trusts, please don't hesitate to contact me on 3221 0013 for a confidential and obligation-free discussion. Thank you for watching.